Well, before I do this, read this off, I want to say this will be a tribute to the best of my ability to Freddy Kassab. At this point, he had been dedicating all of his time to finding and putting away the killer of his daughter and granddaughters. So, at this point, it had been 4 years, a little over 4 years, since they were killed. Well, yeah, it had been 4 years since they were killed. This letter was written on the 25th of February 1974. And it had been over 3 years and 2 months since Freddy got the Article 32 hearing transcripts and he had read them. And we know he had read them like 3 or 4 times. And he was, according to Bob Stevenson, his stepson, he was going through 3 to 5 packs chain smoking a day, reading the Article 32 transcripts over and over. He read them like front to back 3 to 4 times, something like that, and found out that Jeff wasn't telling the truth. It had been over 2 years and 3 months since Freddy took his trip to Fort Bragg, where the CID and Freddy Kassab tried to recreate the events. Freddy was wanting to recreate the events and tried to recreate the events from Jeff's account. Finding out that and then after doing this, going there and trying to recreate the events, and from his story about that night, Freddy realized the real killer was his son-in-law, and so he has done everything to get a trial. At this point, he's been pushing. He was pushing. He sent letter after letter after letter to Congress, to the DOJ, to the federal courts. He's been getting the runaround, and as well as the Eastern District of North Carolina, hopefully trying to get to a grand jury. Jeff and he wanted to get Jeff on trial. And Freddie knew there was enough on him to get to trial, and there's just enough while the evidence, while circumstantial, was piling up, and he sent a letter to the Attorney General, William Saxby. So here it is. The letter to the Attorney General, William Saxby, on February 25th, 1974, his letter. On approximately June the 1st, 1972, the subject case was referred to the U.S. Justice Department's Criminal Division by the U.S. Army with the recommendation for prosecution. Since that time, the case has been assigned to one group of lawyers after another within the Justice Department. Much disagreement has taken place as to the outcome of such prosecution. I've repeatedly expressed the opinion to Mr. Petersen that he does not have the right to prejudge the outcome of a trial prior to the prosecution. There exists in his hands far more evidence that is necessary for an indictment and prosecution. However, the decision has been made by Mr. Petersen not to prosecute. He has advised me that he has referred the case back to the U.S. Army CID command for further investigation, a completely illegal move in my estimation. Since the one and only suspect is a civilian, I've asked Mr. Petersen under what legal authority is he using the U.S. Army to investigate a civilian murder case. Instead of answering my inquiry, he has referred it to the U.S. Army for consideration. Mr. Petersen is attempting to pass the buck on this case. However, there is no way that a U.S. Army can or will legally continue to investigate a civilian, nor will I allow this situation to continue. I intend to pursue this matter into the courts, and in the process expose the lackadaisical manner in which the Justice Department has handled this triple murder case. I've stated before in writing to the Justice Department that I was willing to sign a complaint on 3 counts of premeditated murder against Jeffrey R. McDonald, and I intend now to proceed along those lines with or without the assistance of the Justice Department. If I proceed on my own, you can be sure I will do so in full view of the media. I have not asked for the Department of Justice to prosecute someone they do not think is guilty. I have not asked them to prosecute someone without evidence, nor have I asked them to prosecute a case where the legitimate indictment is not a certainty. I have been frustrated at every turn. However, I still seek a legal solution to my frustration, and I will continue to do so until I feel that there no more can be done by one man as formidable as an entity as the Justice Department. Our country has come to a sorry state when a citizen has to fight the Justice Department in order to get a prosecution of a known murderer. It would have seemed of late that unless the news media or Congress intervenes, nothing is done about the prosecution of any major federal crimes. I swear to you that I will not allow the murderer of my daughter and 2 granddaughters to get away with those brutal murders. You should know before this matter proceeds any further that I have the opinion of a U.S. magistrate that if this case were within his jurisdiction, he would see to it that it was presented to a grand jury. Therefore, I am having a criminal information prepared for my signature and filing. Any attempt to stop me, overt or covert, will have to be explained to the media. The excuse of an ongoing investigation will not hold water anymore. I have in my possession a letter from the U.S. Army dated January 3rd, 1974 that due to your close interest in the investigation conducted by this command and your desire to know the status of action being taken, you are advised that the United States Department of Justice has notified the headquarters that insufficient evidence exists to undertake a prosecution for the death of your loved ones. The foregoing is a direct quote and not taken out of context. I therefore am formally requesting that you instruct the U.S. Attorney for the Eastern District of North Carolina to proceed with this case at once. You advise me in writing that in the opinion of the U.S. Department of Justice, there is insufficient evidence to obtain an indictment by a grand jury. If you have any doubts about the intentions, I suggest you consult the U.S. Army CID Command and the Judge Advocate General's office for confirmation of the fact that I usually do what I say I am going to do. This case was closed once before for all intents and purposes in October of 1970, and at that time I paid a personal visit to the office of every congressman and senator in this country with the result that the case was reopened. I can do this once again if it becomes necessary. There's no way that the U.S. Department of Justice could sweep this case under the proverbial rug simply out of fear that you might lose the case. And that is not because you don't have a case. A prompt reply is requested. Yours truly, Freddy Kassab. February 17th, 1970, my daughter, Mrs. Colette McDonald, and her 2 daughters, aged 2 and 5, were brutally murdered on the federal reservation of Fort Bragg, North Carolina. And since that day, the mishandling of this case has been unbelievable. At my request in December 1970, the House Senate Armed Services Committee asked the Department of Defense to conduct a complete inquiry into the murders. This was done by the Criminal Investigation Division of the United States Army, and it is fact that the FBI has repeatedly refused to participate in this investigation, even though the only suspect is a civilian and the crimes came under their jurisdiction. The Army investigation was completed in May of 1972 after 1.5 years' work. A brief approximation of 10,000 pages and 200 exhibits was submitted to the United States Department of Justice on approximately June 1st, 1972, with the recommendation for prosecution. Since that day, the case has been assigned to several groups of attorneys in the Justice Department. A great deal of controversy was generated not on the questions of the committed crimes or the certainty of the indictment, but on the percentage of chances of conviction. This is due to the fact that the case is a circumstantial one. It has been my argument with Mr. Petersen that the Assistant Attorney General, that the Justice Department does not have the right to prejudge a case if there is probable cause. They must proceed. It is my contention that far more evidence exists in the hands of the Justice Department than is needed for an indictment and the prosecution. It is my understanding that every attorney in the Justice Department who has worked on this case, with the exception of 2, agree. In spite of this, the official position of the Justice Department is insufficient evidence on which to proceed. I assume that the official position of the Army will follow that of the Justice Department in order to prevent an open breach. However, taken individually, those who worked on this case will agree with me by a large majority, including the U.S. Attorney for the Eastern District of North Carolina, who reviewed this case in July of 1973, recommended prosecution. You gentlemen can well ask what possible motive could be that the Justice Department have for not wanting to prosecute a triple murderer. It doesn't sound logical. My connotation is that the trial would attract national attention in the media. The case is circumstantial, one, and they feel that if they lose, thereby making them look bad, their claim is that they must have an 80% chance of conviction before they proceed. I could cite to you hundreds of cases have been successfully prosecuted for far less evidence than the Justice Department. Than the Justice Department has in this case. Furthermore, in a decision on Rule 2, Title 18 of the U.S. Code, Campbell versus the U.S., 1961, interest of the United States in criminal prosecution is not that it shall win a case, but that justice shall be done. A miscarriage of justice and dereliction of duty has taken place in the Justice Department, and I consider it the duty of the Judiciary Committee to inquire into this matter. Not the official position of the Justice Department, not the official position of the Justice Department should be investigated, but the opinion of all attorneys who were involved in this case. I am in possession of enough facts to obtain an indictment, although what I possess is far short of the volumes of evidence in the possession of the Justice Department and the Army. A criminal complaint is presently being prepared by my attorneys, which, when finished, I will sign and file with the U.S. Court in Raleigh, North Carolina, thus forwarding this matter into the open. I have 3 requests of the committee: that the Justice Department be asked to reply to my accusations against them not proceeding with a case in which they have the necessary evidence; that the Justice Department be asked why, in spite of the fact that the one and only suspect in these murders is a civilian, they insist that the criminal investigation of the U.S. Army do the investigating, when it is in fact that the Army does not have subpoena power or legal authority to interrogate or investigate civilians. And 3, to ascertain on legitimate grounds, and what are legitimate grounds, the FBI has repeatedly refused to actively investigate a triple murder committed on a federal reservation when the one and only suspect is a civilian. Respectively submitted, Alfred G. Kassab, on 17 February 1970, Our daughter, Mrs. Colette McDonald, and her two daughters, ages 5 and 2, were brutally murdered on a federal reservation on Fort Bragg, North Carolina. Since the 1st of June 1972, the U.S. Department of Justice has had its hands on a prima facie case against Dr. Jeffrey R. McDonald, which was submitted to them by the United States Army with a strong recommendation for prosecution. For reasons of their own, the Justice Department has neglected to act, even in the face of our constant demands for a prosecution. We therefore, on this date, have sworn out a criminal complaint in federal court before the Chief Judge Algernon Butler in the Eastern District of North Carolina, charging 3 counts of murder against Dr. Jeffrey R. McDonald, and have asked that a warrant be issued for his arrest. Your deponents, Alfred Kassab and Mildred Kassab, respectively allege, during the nighttime hours of the 16th and 17th, 1970, at the United States Military Reservation at Fort Bragg, North Carolina, within the jurisdiction of this court, Colette McDonald and Kimberly McDonald and Kristen McDonald were stabbed, bludgeoned to death. Colette McDonald was 5 months pregnant with a child and was 26 years of age. Kimberly was 5 years of age. Kristen McDonald was 2 years of age. And the daughters of Colette McDonald, the defendant, and were the daughters of Colette McDonald, the defendant Jeffrey R. McDonald, then a captain in the United States Army. Your deponents, Alfred Kassab and Mildred Kassab, are respectively stepfather and mother to Colette McDonald, the grandparents of Kimberly and Kristen McDonald. During the months of July to October 1970, Jeffrey R. McDonald was the subject of a respondent in a hearing conducted by the Department of the United States Army, Article 32 of the Code of Justice Military. The purpose of the hearing was to determine whether or not probable cause existed to hold the respondent for further criminal proceedings arising out of these incidents. On October 13, 1970, the hearing officer duly assigned by the Department of the Army ruled that the probable cause to prosecute the respondent did not exist on the basis of insufficient evidence, and had the charges dropped. During the course of the Article 32 proceeding, the deponent Alfred Kassab testified as a witness for the defendant Jeffrey R. McDonald. The deponent participation in the proceedings on the side of the defendant received public notice because of the fact that the deponent was related to the victims rather than to the defendant. Subsequent to the conclusion of the Article 32 proceedings, the deponents received and read complete transcripts of the proceedings which had been closed to the public, and as which the deponents and had little knowledge with what was going on in the said proceeding. On the basis of the full review of the transcript of the said proceedings, the deponents' personal knowledge and newly discovered evidence, the deponents now believe that Jeffrey R. McDonald was the perpetrator of the crimes which occurred on the 16th and 17th of 1970. A review of some of the evidence available to the deponents or within their own personal knowledge is contained with a pre-arrest complaint. And in the affidavit of the former chief warrant officer Peter F. Kearns, which have been filed simultaneously here within with the chief judge of this court. The Criminal Investigation Division of the Department of the Army, on or about the 1st of June 1972, transmitted to the United States Department of Justice a report consisting of approximately 3,000 pages reviewing all evidence available at the time to the Department of Army, and upon information and belief strongly recommended to the Department of Justice that Jeffrey R. McDonald be prosecuted for said crimes. A copy of the report was made available to the deponents your deponents or the public, and your deponents' knowledge thereof is based upon information received by your deponents from the Department of the Army. If it had been available to deponents, it would have been filed within the complaint herein. It would be in the interest of justice for a copy of the said report, together with any other CID recommendations to the Department of Justice, to be considered by this court with its determination as whether or not to probable cause exists under the Rules 3 and 4 of the Rules of Criminal Procedure to issue an arrest warrant for the defendant. The Department of the Army concluded on June of 1972 that it still believes the evidence is sufficient enough to establish a prima facie case against Jeffrey McDonald. A copy of the letter sent from Stephen Kula, Major Judge Advocate General Corps Staff Judge Advocate, U.S. Army CID Command, dated March 20, 1974. So stating it is annexed in title Exhibit A Herito. We are advised that Exhibit A was transmitted to the undersigned with the knowledge that the consent and approval of the General Counsel, Department of the U.S. Army, the accompanying affidavit of former Chief Warrant Officer Peter Kearns, the author of the report mentioned in the paragraph 7, is also relied upon to establish the statement contained here within. In or about July 1973, Thomas P. McNamara, the United States Attorney in Raleigh, North Carolina, forwarded to the Department of Justice memorandums analyzing the evidence available to the United States Attorney's Office upon information and belief recommending that the defendant Jeffrey McDonald be prosecuted for the aforementioned crimes. Despite recommendation of the Department of the Army mentioned in paragraph 7, the conclusion of the Department of the Army mentioned in paragraphs 8, and upon information, belief, the recommendation of the United States Attorney mentioned in paragraph 9 that the Department of Justice declined thus far to initiate a prosecution of the defendant. Simultaneous to this filing of this pre-arrest complaint, mentioned in a paragraph of 6 hereof, deponents have asked the Attorney General of the United States appoint a special prosecutor for this case pursuant to 28 U.S.C.A. S. 510. A copy of the deponent's request to the Attorney General is annexed as Exhibit B Herito. Your deponents wish to have the case vigorously and fairly prosecuted, wish to have a special prosecutor appointed, and respectfully ask this court, upon review of the pre-arrest complaint filed herein, to issue a warrant of the arrest for Jeffrey R. McDonald pursuant to Rules 3 and 4 of Rules of the Criminal Procedure. And it is in the interest of the justice that the court of direct it is in the interest of justice that the court direct the Criminal Investigation Department of the United States Army to file with the court a copy of its report and analysis and evidence in this case, together with the copies of any and all other CID recommendations to the Department of Justice, that the court direct the United States Attorney to file with the court a copy of prosecutive memorandum dated July 1973, so that the court, exercising its judicial function under Rules 3 and 4 of the Rules of Criminal Procedure, may before it all of the evidence and information which it might reasonably require to make a determination. The complaint is filed with the chief judge of this court in accordance with Rule 3 of the United States Rules of the Criminal Procedure, requiring a complaint to be made under oath before a magistrate. Under Rule 54 of the Rules of the Criminal Procedure, a magistrate includes a judge of the United States, and it is deemed appropriate that in a case of such extreme importance that the determination of probable cause should be made by a judge of this court rather than a United States magistrate. As an alternative to the above-mentioned relief, in accordance to Rule 6 of the rules of the Criminal Procedure, deponents request the court to order a grand jury to be summoned to hear the evidence in this case on the ground that the public interest so requires, and that the court direct the United States Attorney to cooperate with the grand jury to present any and all evidence in this case to such a grand jury. Simultaneously with making this application, deponents are transmitting a copy of this affidavit and the motion of the complaint to the United States Attorney General of the United States and to the General Counsel of the Department of the Army, both in Washington, D.C., so as to afford both departments of the federal government a reasonable opportunity to address themselves to proceedings herein. Wherefore, your deponents pray for an order to be issued by this court, directing the Criminal Investigation Department of the Army to file with the court a copy of the report of the department dated on or about June 1st, 1972, together with any and all supporting documents and any and all other CID recommendations to the Department of Justice, directing the United States Attorney Thomas P. McNamara to file within the court of his prosecutive memorandum dated July 1973, and for such other relief as this court deems appropriate to protect the integrity of these proceedings, and in connection with the filing of the criminal complaint, that a warrant issue for the arrest of the defendant Jeffrey R. McDonald, or as an alternative to the prayer for its relief, be designated, that in accordance with Rule 6 of the Rules of the Criminal Procedure, order a grand jury summoned to hear the evidence in this case, that the United States Attorney can be directed to cooperate with such a grand jury in its investigation of this matter. And Mildred Mildred Kassab signed, and this was sent by their attorney to the Eastern District of North Carolina, and dated April 30th, 1974. Alright, I'm going to read off as another, I guess, tribute to Mr. Freddy Kassab, his letter to U.S. District Court Judge Algernon Butler from the Eastern District of North Carolina. Sir, the time has come when I must speak out with regard to the lack of interest of the Justice Department and the court has shown to the criminal complaint my wife and I filed with the court 2 months ago. The last time I wrote you, Your Honor, I was told by my attorney that one does not need to write letters to judges. It just is not done. Well, I was also told almost 4 years ago I could not get a reinvestigation of the murders. I did get it accomplished. However, even with the results that were produced, my fight with the Justice Department has proved to be far more disheartening. I now have nothing but contempt for that organization who are supposed to uphold the laws of this country and humanity. The fact that my wife and I have had to go through what we have in the last 4 years speaks very poorly to the justice and the system of laws, as well as to those who administer them. We have not asked that someone be prosecuted that authorities do not think is guilty. We have not asked someone to be indicted where the outcome of a legitimate grand jury hearing is not predictable. Nor have we asked someone to be prosecuted without evidence. I am positive that if the tables were reversed, and Your Honor and had asked us to supply you with information 2 months ago, and we not done so, Your Honor would most certainly have taken some kind of action against us. And it is also a certainty that if the Justice Department had asked for an arrest warrant and or a convening of a grand jury, they would have received prompt action. Why are we any different? We are responsible people who have acted responsibly. No one can say that we have not shown probable cause in our complaint. The Justice Department has gone too far. The Justice Department has had far too much time given to them to prepare their case. While we do not have the means to hire a high-powered, high-pressure attorneys, we don't. In fact, we can't even pay our present legal fees. We do have the determination to see to it that the murder of our daughter and 2 granddaughters is brought to justice. In that determination, to the date, we have shown great restraint. We have not given in to our own instincts for personal vengeance on the assumption that we can get justice to do what is supposed to be done. The time for procrastination is long past. We surely have the right to a determination by now. The gravity of the charges dictate it